So tonight is effectively a fireside chat, without the fire, I'm sorry to say, but a fireside chat between Professor Bjorklund and Yves Fortier. And it's part of an oral history project that was initiated a couple of years ago. It's part of the activities of the Institute for Transnational Arbitration. And it's useful to know that Andrea is the president or chair of the Academic Council of the ITA. So as some of you may know, there have been other fireside chats of this nature, the purpose of which is to capture in video and eventually in writing the wisdom and experience of great arbitrators and arbitration practitioners. And this is what we will witness tonight. So there have been others before. The first one was between David Caron and George Berman in the Winter Forum of 2012, and then there were a couple more conversation between Linda Silberman of NYU and Gary Bourne, and then a conversation between Chip Brower and Charlie Brower. So tonight, the guest of honor, or the person who will share with us this great insight about the practice of arbitration is our dear friend, Yves Fortier. And I know that all of you know him well, and that's why you're here in such great numbers. But let me take a moment to highlight Maître Fortier's accomplishment. As you know, he was Canada's ambassador and permanent representative to the United Nations in New York, and Canada's chief delegate to 4 sessions of the General Assembly, served as Canada's representative to the Security Council and president of the Security Council in 1989. And if that were not enough, you also know that before going to the United Nations, he had an extraordinary legal career, member of the Permanent Court of Arbitration at The Hague, representing Canada in a variety of international disputes, as well as being counsel on many royal commissions and commissions of inquiry in Canada. So a career as a lawyer first, then a career as a diplomat, and then again a career as a lawyer, back to his alma mater, one might say, Ogilvy Renault, now Norton Rose, and Norton Rose Fulbright. Norton Rose Fulbright Dvorsky, I think, is, I'm having a tough time keeping track of all these transformations of our market for legal services. Maître Fortier, as you know, left Norton Rose recently, and he practiced as an independent mediator and arbitrator, but continues to be, as I said at the very outset, a very loyal and supportive friend of the Faculty of Law, a graduate of the class of 1958. He moved on to Oxford University, where he received a Bachelor of Letters before being called to the bar in 1960. And he's been obviously rewarded with a number of signs from the community of scholars and Canadian community for his extraordinary contributions to Canadian life. He was appointed Officer of the Order of Canada in 1901, elevated to the rank of Companion of the Order of Canada, the highest rank of the Order. In 2006 was made Officer of the National Order of Quebec, numerous honorary degrees from universities in Canada, and most recently the Roger Fisher Lifetime Achievement Award, which was awarded, I think, this past fall, probably in the presence of a number of you. And so without further ado, I turn to our speakers tonight for this fireside chat conversation without a fire. Thank you.
Okay. Thank you, Dean Dutra, for that very generous introduction. I am especially grateful to Yves Fortier for having agreed to be part of this oral history project of the Institute for Transnational Arbitration, and I very much look forward to this conversation. Daniel has already started to introduce Yves. You know, he is one of the leading arbitrators in the world. He has sat as an arbitrator in more than 100 commercial cases and in scores of investment arbitrations. He is also an accomplished litigator, a senior diplomat, a company director, and a public servant. He has been governor of McGill University, a director of the Montreal Neurological Institute, chairman of Alcan, governor of Hudson's Bay Company, and is a vice chairman of Historica Canada. I think I didn't repeat much of what Daniel said in adding to Yves' illustrious list of accomplishments and works. And he is now a member of the Queen's Privy Council for Canada, another new addition to your portfolio. But I want to start kind of back at the beginning. Here we are at McGill in the law faculty. When you were in law school, first at McGill and then at Oxford as a Rhodes Scholar, were you interested in international law and arbitration?
Not at all. I was not. You told me to give you honest answers in the course of our fireside chat. So no, I was not thinking at all of international law when I was at McGill. Or when I was at Oxford. But before I go on with my reply to your first question, Andrea, let me congratulate you for having been designated, elected, whatever the term is in university parlance, as the holder of the chair. It's a great honor for me to see that someone of your distinction was approached, deserved to be approached, and more importantly, accepted. So again, congratulations et puis bonne chance.
Well, thank you, Yves. It is such an honor to have been named to the Yves Fortier chair. I hope that I live up to the confidence you place in me.
I wanted to add that about 2 weeks ago, Andrea was giving a lecture in Geneva, and unbeknownst to Andrea, one of my wife's nephews was in the audience, and he sent an email to Carol after Andrea's lecture, and he said that he had refrained from approaching Andrea. But he was curious to know what the Yves Fortier chair was made of. what kind of wood was the chair made up of? And I don't know if some of you must have been in Quebec, more specifically in the Eastern Townships, a few days before Christmas when we had an ice storm, and we have a property there on Lake Memphrey-Magog, and we lost a cedar hedge, and we lost a number of trees of some significance. So Carol replied, "Well, we have an embarrassment of choice of wood on the property in Magog." I think if Yves had to decide which wood his chair should be made up of, he would have chosen cedar. So that's a short vignette of Derek also added that he thought you gave a superb lecture, which doesn't surprise me. But no, when I was a student here at McGill many years ago, I was not thinking at all in terms of international law. I was thinking in terms of the civil law. I was thinking in terms of criminal law. I was thinking in terms of Roman law. I was thinking in terms of constitutional law, which I like very much. And when I went to Oxford, I wanted to learn the rudiments of the common law. So I took a course in contracts and a course in trusts, which of course I hadn't done too much of in the civil law facet of my education here at McGill. And international competition la in particular. I had un faible pour le droit de la concurrence. In fact, my thesis, the subject of my thesis at Oxford, was the law of resale price maintenance in the United Kingdom, in the United States, and Canada, believe it or not. And I had as a tutor a person by the name of Jeremy Lever. Today, Jeremy went on to become the best known competition lawyer really in Europe. And about 1.5 years or 2 years ago, I was appointed as chairman of an LCIA tribunal with a very, very accent on competition law. And lo and behold, I hadn't seen Jeremy for over 50 years. I found myself sitting with my former tutor on this tribunal.
Fabulous.
Yeah, absolutely fabulous for me. And if I believe him, he said it was fabulous for him.
I believe him.
And my other wing person, so to speak, took me a while to call him Lenny, but it was Lord Hoffman, of House of Lords fame. So there were Lenny, Jeremy, and Yves sitting on this tribunal, and it was a marvelous experience, absolutely sensational experience. But it just goes to show that you never know where your studies are going to lead you. Yes, they did eventually, maybe we'll come to it later, but they did eventually lead me to international law. But when I came back from Oxford, what I wanted to do was so-called antitrust, cartel, and I went and I had an offer before I left for Oxford to join what became Ogilvy Renault. In those days it was called Common Howard Cade Ogilvy. And I went and saw Mr. Howard, and I said, Mr. Howard, I would like to practice in the area of competition law, antitrust, the Clayton Act, and so on and so forth. And he looked at me. I was then about 24 or 25, and he said, Mr. Fortier. He called everyone Mr. Fortier, or Madame Clark, as the case may be. You are not going to specialize in any branch of the law. At Ogilvy Renault, or whatever it was called then, we want our young lawyers to do a little bit of everything before they specialize. Times have changed. Maybe we'll touch on it later. But he said, I want you to do a little bit of everything. In 10 years from now, if you feel that you would like to specialize in competition law, come back and see me. And in the meantime, go to your office and start doing a little bit of everything.
So that was your first legal job at Ogilvy Renault?
Yes.
And so tell us a little bit more about that. What did you find most exhilarating as you first started practicing? What did you find most difficult, if anything?
Oh yes, certainly. You've just opened the door to another answer, if anything. I remember when I was knee-high to a grasshopper and going to school in Quebec City, and le jour de l'an, on allait toujours chez nos grands-parents, et puis tous mes cousins, mes cousines, on leur disait bonne chance dans tes études, j'espère que tu vas travailler bien puis que tu vas réussir. Et quand on arrivait, j'étais l'aîné, on était 24 cousins, cousines, et quand on arrivait à Yves, on lui disait toi Yves, tu réussis très bien, on n'est pas obligé de te souhaiter bonne chance. Et j'avais de la difficulté à dormir ce soir-là, puis je disais toujours à mon père et à ma mère, mais est-ce qu'ils ne pensent pas que si je réussis, c'est parce que je travaille? Puis si je travaille, j'ai besoin qu'on me souhaite bonne chance pour pouvoir réussir. Alors, donc ça c'est bien longtemps avant que j'arrive au droit, mais j'ai toujours voulu devenir avocat. C'est pas une vocation de dernière minute. J'ai toujours voulu devenir avocat. Ceux qui me connaissaient et qui me connaissent bien, qui sont prêts à dire la vérité, ils vont dire c'est bien normal, tu étais toujours en train de nous engueuler. So I wanted to become a lawyer, and when I remember at Collège Sainte-Marie, when I went to choose my ribbon, we had la cérémonie des rubans. Je ne sais pas si ça existait dans ton temps, monsieur le doyen, mais il y avait alors le ruban blanc, et tous les jésuites espéraient que les élèves choisissent le ruban blanc. Évidemment, ça voulait dire la prêtrise. The red ribbon was medicine, the green ribbon was engineering, and the blue ribbon was the law. And I knew from the day that I entered Collège Sainte-Marie for my cours classique, I always knew that I wanted to choose the blue ribbon. And the time came, it didn't surprise anyone. And yes, I came to McGill. All my friends were going to l'Université de Montréal, and I wanted to go to l'Université de Montréal with them, but my father, who was a very wise man, he was not a lawyer. I had some lawyers in the family, but he was not a lawyer. He said, Yves, you should go to McGill. I said, Papa, mais pourquoi aller à McGill? Je ne parle pas assez bien l'anglais pour aller à McGill. Et puis, il m'a dit, tu sais, les anglophones qui vont être assis à côté de toi là, à McGill, ils n'ont jamais fait de droit en anglais, eux autres non plus. Alors, il y a une petite lumière qui s'est allumée et j'ai dit, ouais, OK, très bien, tu m'as convaincu, je vais aller à McGill. And I never regretted it. I made some wonderful friends. This was in the days of Dean Meredith, Frank Scott, Max Cohen, Louis Baudouin, Phil Weinberg, Jean-Guy Castel, Jerry Ledane, whom I see over there. Had some wonderful professors, and those were 3 very enriching years. And then Oxford, and then I came back, and yes, after my brief encounter with Mr. Howard, I went to my little office, and I started doing what I thought I would be doing, that is litigation. I became a trial lawyer, and I remained for many years a trial lawyer. It was very invigorating in those days to be a trial lawyer, to go to court. I remember some years I went to court literally every day between Christmas and Saint-Jean-Baptiste. Every day I was in court for one purpose or another. It may have been just a little motion for particulars. It may have been a trial. We acted for Wawanisa, so we had a lot of Wawa, we call them, cases. Automobile accidents. In those days, it was before l'assurance sans faute. We had trials for a few $100s. I remember there was a Judge Denis, and you walked in, he presided over a lot of automobile accident cases, and you walked into his courtroom, and he had a board with little motor cars and intersections. And Maître Fortier, je voudrais comprendre, où était la voiture de votre client? Alors là, monsieur le juge, la voiture du client, elle était juste ici, là. Est-ce que la lumière était rouge? La lumière était rouge ou verte? La lumière était verte. Il pesait sur un bouton, la lumière s'allumait. Puis après ça, il continuait. Et vous, l'avocat, des fois, je m'entendais très bien avec le juge Denis. Il s'adressait à mon adversaire, puis il disait, « Et vous, qu'est-ce que vous prétendez? Où était la voiture de votre client? » La voiture était verte. Est-ce que la lumière était verte ou ça était rouge? Mon adversaire disait, la lumière était verte, évidemment. Il dit, les deux lumières ne peuvent pas avoir été vertes en même temps. Alors, il dit, je vais laisser la lumière du client de Maître Fortier verte, puis la vôtre est rouge. Anyway, and then the firm was doing a lot of work for the Royal Bank of Canada. Including in those days, all the preliminary, les enquêtes préliminaires, c'est ça, enquête préliminaire, preliminary inquiry, leading, to see if there was enough evidence to go to trial. And I did a lot of those with the detectives for the bank. And so this brought me before the criminal courts. There were very few of us white-collar lawyers at Ogilvy Renault in those days who did criminal work. And one day, I was representing the bank, and this person came up to me, and he said, en français, c'est est-ce que vous accepteriez, Maître Fortier, de représenter mon, je sais pas, c'était mon neveu, mon cousin, whatever. De quoi est-il accusé? Il est accusé d'un vol de banque. Je ne sais pas comment mon l'associé senior à ce moment-là, c'était Angus Ogilvy. J'ai dit, je ne sais pas comment M. Ogilvy aimerait savoir qu'un des jeunes avocats au bureau représente quelqu'un qui est accusé d'un vol de banque. Mais j'ai accepté le mandat. Et puis, je l'ai défendu avec succès. Il y avait un alibi parfait. Et le lendemain ou le surlendemain, il y avait un article, la première page du Allô Police, c'est ça, Allô Police. Puis ça a marqué « Le futur Raymond Daou ». Il faut que vous sachiez que Raymond Daou était le plus grand criminaliste au Québec à l'époque. Le futur criminel, puis il y avait une photo d'Yves Fortier. Ah ben, alors, quand je suis arrivé au bureau, mon mentor, parce que j'avais un mentor qui s'appelait Tommy Montgomery, il dit, Yves, have you bought all the editions of the Hello Police? Says, if Angus Ogilvy sees this, he's not going to like it. So that was my sole foray into the real criminal law.
Well, so you mentioned one mentor.
Yes.
Did you have, I mean, tell us a little bit more about him and other mentors early in your career. What did you learn from them?
Well,
Besides buying all the newspapers.
in the law firm at the time, the senior litigator was called Thomas Montgomery, QC. And Thomas was everybody's favorite in the firm, everybody's favorite senior partner. He always had time for you, except for 15 minutes after lunch. The door to his office was always open. By 15 minutes, the door was closed because he took a nap after lunch every day. And Madame, what was the name of his secretary, as we called them in those days, Ms. Dimmick. I remember you were not allowed to come within 15 feet of Mr. Montgomery's door, but otherwise the door was open, and you could always go to him and tell him about your day in court, tell him about your future day in court. And he had very, very wise counsel, very wise advice, and I love the man. He was one of those. Well, two things I'd like to say. Occasionally, I would come back after a long trial, and I would walk by his office, and I'd say. By then, I had learned to call him Tommy. I remember he had said, if you don't call me Tommy, I'm going to keep my door closed all the time. So I called him Tommy, and I said, Tommy, I've just finished this 2-week hearing. I have absolutely nothing to do. What am I going to do? And he would look at you and he would say, my boy, enjoy. And sure enough, the phone did ring occasionally afterwards. But the other thing I remember about Mr. Montgomery was he had a hobby. It's so important to have a hobby other than what you do for a living. It was il était ébéniste. He was working with wood, and he and his wife had a house on the same lake but down the lake near the Vermont border in BB, and he had an atelier where he did the most beautiful chairs, tables, etc. And when he reached the age of 65, contrary to many of us, he was anxious to retire, and he turned his back. He went on the Eastern Township autoroute, and I don't think he ever came back to Montreal. He just wanted to work with wood in his atelier, and we went. Carol and I were invited to have dinners with them occasionally, and he was a very, very happy man. But I've also met a lot of lawyers, men and women, who have retired without a hobby and have in no time started to dépérir, regrettably. That is in part the reason why at my venerable age I continue to practice 24/7, because I love doing what I'm doing.
Well, that's a perfect lead-in to what was your first experience with arbitration? What was your first experience as counsel? What was your first time as arbitrator?
Well, Andrea, as I said, I did a lot of litigation. Superior Court, Court of Appeal, Federal Court, even the predecessor to the Federal Court, which was called the Exchequer Court of Canada, and the Supreme Court. And I was always looking for more, and I did, as Le Doyen generously said, I did a few commissions of inquiry. That's counsel work, obviously. And one day I was contacted by the president of a company. I remember the name. It was Patino Mining Corporation. Patino was a nickel, mainly copper and nickel mines in Chibougamau in Quebec. That's why they'd come to me for some issues in Chibougamau, and also around the world, including in La Nouvelle-Calédonie in the Pacific, New Caledonia. And they had a dispute with the Bureau BRGM, le Bureau de Recherche Géologique et Minière. And this was going to be an arbitration, an ICC arbitration. I had no idea what it was, and they asked if I would represent them, and I learned about the dispute and the ICC, and of course one of the first things you ask when you start an arbitration is what is the venue, where will we sit? And I remember Patrick was his name, Pat Keenan, said, "Well, I'm sorry. This. I thought I turned this off." He said, "Yves, you're not going to like this, but the venue, the place of arbitration, is Paris." I said, "Well, if you have to go to Paris, you have to go to Paris." And so I was retained. And we appointed our arbitrator, and the BRGM, which was an offshoot of the French government, appointed its arbitrator, and well, there is a side story which I'll pass over it for the time being. But so we had hearings in Paris, and in those days, it was in the days of the Concorde. And the client thought that my time was very valuable. I was then, this was in the late 70s, I guess. So I was about 40, 45 or so years of age. And he thought, the client thought that I should travel on the Concorde to go to Paris. And I took the Concorde to and from Paris via New York, of course, via Kennedy, about 15 times in the course of the following 2 years. The arbitration lasted, and we had a good outcome. The client was very, very pleased, and I discovered what arbitration was all about, international arbitration, and I liked it. I liked it very much. So I had a few more cases as counsel. The second leg of your question is, what about work as an arbitrator? Well, I have to skip over my 3.5 years in New York, but
we're going to get back to that.
You get back to that, okay? Okay. So I'll for the time being, I'll just say that when I came back from New York, I didn't want to go back to arguing cases in the Superior Court or in the Court of Appeal, for that matter. I wanted to do some arbitration, but you can't simply hang up your shingle and say, Yves Fortier, arbitre. It doesn't work that way. You have to be at the right place at the right time. You have to become known in the world of international arbitration. You have to if possible, you have to go to a few symposia, a few meetings of the IBA or the LCIA or the AAA, and you have to write a few articles on one aspect or another of international law, arbitration, and eventually, if you're lucky, somebody will ring your doorbell, but we'll come to that in a few moments.
Well, let's talk about your time in New York. You were appointed Canada's ambassador and permanent representative to the United Nations in 1988, and this meant that you were also, I guess, how did you come to be appointed? And, yes, tell us about that.
Obviously, like every other question, you expect me to give you an honest answer. So I'll tell you the truth. Again, I open a parenthesis. I remember I had a witness one day, and I was not woodshedding him, but I was preparing him for his evidence. And he said, Mr. Fortier, I understand what you're saying. I have to tell the truth and nothing but the truth. I said, yeah. But he said, do I have to tell the whole truth? And that really registered with me, as you say, to this day. I remember do I have to tell the whole truth? But okay, back to your question. It was never being a diplomat was never on my list of things to do, Andrea.
There wasn't a ribbon that said diplomat.
No, there was no. I was very happy at practicing law. I had as a partner. He joined the firm about 3 years after I did. Somebody called Brian Mulrooney, and we had become not good political. I stress, not good political friends. In fact, in those days, he and I were not at all of the same political ilk, but we were very good friends. And when Brian became Prime Minister, he very generously looked to me how would you like to do this? How would you like to do that? And I always turned him down because, I repeat, I was very, very happy practicing law, and I had no ambition doing anything else aside from continuing to practice law. And one day he did call and he said, Yves, there will be an opening in New York. Our ambassador was Stephen Lewis at the time. And he said Stephen is retiring, and Canada will be going on the Security Council. We had to run for the position, enter into an election contest, but we had contrary to the situation that obtains today, Canada had a very good reputation at the UN in those days, and it was pretty much of a fait accompli that we would be elected. So we were going on the Security Council, and this, as you said, this was in 1988, and he said, I'd like to appoint you, because when Canada's on the Security Council, I would like to have someone like you. I know you very well. Maybe he knew me too well. He said, I know you very well, and I'd like to appoint you. So I said, well, look, I'm not sure that I'd be interested, Brian, but well, he said, come on up to 24 Sussex. So I got into my car a couple of days later, and I went to Ottawa, and a la Mulrooney, I've always said, if Brian could have met every Canadian one-on-one, he would have been Prime Minister for life. But when he was speaking to large groups of persons, it was as if he had kissed a Barney stone a little too often. But anyway, so I came back. I said, let me check with the two bosses in my life, Carol, of course, number one, and number two, the then senior partner, who was Mr. Howard's son, Ken Howard. So I consulted with both of them. Carol thought that Yves at the UN and Carol at Bergdorf sounded like a heck of a combination. And she was quite enthusiastic. Our last child was getting ready to leave the nest, so the timing was perfect. And as I kept saying to myself, you know, New York is only 1 hour away by plane. So and my partners eventually very generously said, okay, if you want to go, you go. But on one condition, promise, I was very humbled, promise that when you finish your term, you're going to come back to the firm. And I did give my word, and I kept my word. And as they say, the rest is history, because I went, we went, my wife and I, we loved it. And yes, I ran out of New York, Canada's campaign for a seat on the Security Council. And boy, what a change a few years make. The night, the evening that the votes were counted, Canada had more votes than any other country running for a non-permanent seat on the Security Council had ever gathered since the charter was signed in San Francisco, in 1945. And on the 1st of January 1989, I took Canada's seat on the Security Council. And you know, being at the right place at the right time in life, I've always said, is very important. Some of my friends don't believe in, they call it luck, and you shouldn't say that you make your own luck, and to a large extent you do. But although apocryphally, during the years that I was on the Security Council, I would sometimes come to Canada and give conferences, give speeches, and you may recall, some of you may recall, 1989, 1990, those were the golden years of the Security Council, of the UN Security Council. It was the end, we talk about the Arab Spring a couple of years ago. This was when the Berlin Wall came down. This was when the Soviet Union disintegrated. This is when Nelson Mandela was freed. This was when the first Gulf War happened, in the summer of 1990. And there I was, sitting dans les premières loges des débats de la communauté internationale. And apocryphally, I say that when I accepted the Prime Minister's offer, I said, okay, I'll go on one condition, that you promise me that the Cold War is going to end, that the first Gulf War is going to take place, and that Nelson Mandela is going to be freed. But all these things happened, and I was there. And we used to pinch ourselves when we came for a meeting of the council, and something new had happened overnight almost. It was extraordinary, which is why when people say, the Arab Spring, starting in Tunisia and on to Egypt, how the earth shook. Well, the earth shook in 1989, 1990, and I had the privilege of being there. And yes, I stress, I had the privilege, and I loved every moment that I spent in New York.
You were later appointed personal representative and mediator by the Secretary General of the United Nations in the Equatorial Guinea and Gabon boundary dispute. I understand that there were some tense moments during that engagement, and I wondered if you could tell us the story. I have an informant in the audience.
Obviously, you have been speaking to one of my enemies. No, when I was in New York, I got to know Kofi Annan quite well. He was then in charge of first it was HR at the UN, and then in charge of peacekeeping. And I remember that he and I traveled to Namibia, because when I was president of the Security Council, there was a vote that took place in Namibia, which until then, as you know, had been a South African protectorate. So we traveled, Kofi Annan and Yves Fortier, we traveled together and we spent about a week together overseeing the elections and the vote. in Namibia, and so I got to know him very well. And when I returned to Montreal, occasionally we would speak on the phone, and I remember one day I was playing tennis in Magog during my vacation, and I would leave the house and I would say our daughter, one of our daughters, spent the summer with us. In those days, she still does with her 3 children, and I would say, I don't want to be bothered unless, I would say jokingly, Secretary General of the United Nations or the Pope are phoning. And Margot came over on a bicycle and she said, "Papa, le secrétaire général des Nations Unies veut te parler." So I got on the handlebar of her phone, and I went back home, and I returned the call, and it was the Secretary General who was asking me if I would accept to be a special representative. There was a boundary dispute, a maritime boundary dispute off the coast of Africa, of Western Africa, between Gabon and Equatorial Guinea. And I made a number of trips to the region, and because I was the Secretary General's personal representative, I had access, obviously, to the president of each country. President in Gabon was President Bongo, and in Equatorial Guinea was President Nguyen, something like that. I could tell you a lot of stories, but I think I know what you're referring to. I was traveling either in a Gabonese jet or in an Equatorial Guinea jet from one capital to the other. And as long as I continued my discussions with the presidents, things went very well. It was when I left the president's office, and then the ball or the baton would be handed to one of his ministers. And then this was when all the deals that I thought I had negotiated with the president came asunder. So one day I'm sitting with him alone, one-on-one with President Bongo, and I'm saying, here's my proposal. And he said, well, Monsieur l'Ambassadeur, we spoke French together, ancienne possession, ancienne colonie française. Monsieur l'Ambassadeur, est-ce que vous pouvez me garantir que si je dis oui, que mon cousin, tous les Africains sont cousins, mon cousin en Guinée équatoriale va aussi dire oui. J'ai dit, je suis certain, je l'ai vu hier dans son bureau privé, et il m'a dit qu'il était d'accord. Bon, je vais l'appeler. He would take what, I guess for President Obama, would be the red line, and he directly to his cousin in Equatorial Guinea. J'ai l'ambassadeur Fortier ici avec moi, là. Il me dit que tu es prêt à accepter ce qu'il m'a proposé. Est-ce que c'est vrai? I couldn't hear the answer, but obviously the answer was oui, je suis prêt. T'es mieux de respecter ta parole, parce que sans ça, je le jette en prison. Effectivement, il a respecté sa parole, but about 3 days later, the ball was back in the camp of the ministers, and the deal came asunder. But I remember after I'd made this deal with President Bongo, he called in his negotiators, and one of them was known to be his mistress, one of his many mistresses, and he said, je viens de donner ma parole à l'ambassadeur Fortier, voici ce que nous allons faire. And the Minister of Constitutional Affairs, I remember, and she said, mais Monsieur le Président, And almost like Maurice Duplessis once told somebody in the National Assembly, he looked at her and said, "Toi, tais-toi." J'ai donné ma parole à l'ambassadeur Fortier. J'ai parlé, "Toi, tais-toi." And well, I'm here. I never went to prison.
Yes, excellent. We're delighted. You then went back to Ogilvy Renault, and that's when you really built up the arbitration practice.
Yeah. Yeah.
And so what was your first time as arbitrator?
Well, you know, I'm going to use again the expression being at the right place at the right time, Andrea. Merci, Monsieur le Doyen. Vous faites bien les choses ici, hein? Tout ici. Merci beaucoup. Yes, as I said, I wanted to do arbitration. I had some experience as counsel. I had argued on behalf of Canada before the World Court the Gulf of Maine case against the United States before going to New York, and I liked the international flavor of that case. And I told you about my arbitration on behalf of Patino Mining. This is very rude. I am very, very sorry. I thought I had turned it off. Let me just put it on silencieux. Take 1 second. 2 seconds. Silencieux, excusez-moi. I'm very sorry. In fact, I hate people who do that to me when I'm sitting as an arbitrator. My sincere apologies. I remember once saying to Louise Arbour after she was invited by Kofi Annan to become head of the Yugoslav, the ex-Yugoslavia, the tribunal for ex-Yugoslavia, and she was sitting on the Supreme Court of Canada, and I had the privilege of knowing her, and she called me and she said, "Yves, est-ce que je devrais accepter?" J'ai dit, "Louise, je sais exactement la réponse que tu veux que je te donne." Une fois que tu as goûté à l'international, c'est très difficile de revenir sur le plancher des vaches. Et effectivement, elle a accepté. Alors, j'avais le goût de l'international et j'avais goûté, comme j'ai dit, à la Cour internationale de justice à La Haye. J'avais goûté à l'arbitrage à Paris. So I decided that arbitration, international arbitration, the center of international arbitration was then, I'm in 1993 then, now, was London, and it remains London. There's a lot of activity in The Hague, of course, in Paris, in Geneva, in Washington, but the hub, the principal hub of international arbitration is London, where the large firms of solicitors like Freshfields, Clifford Chance and Allen and Overy and so on have their quote unquote head offices. We had Ogilvy Renault had a small office in London, and the partner in charge of the office was Andrew Fleming, whom I knew very well. And I phoned Andrew and I said, "Andrew, I'm back from New York. I've got nothing to do at the moment, and I'd like to do some arbitration." I said, "If I go to London, will you arrange for me to meet with the arbitration partners in those large law firms?" And he said, "Avec plaisir." So he arranged, and I went to London, and one of the firms that I visited was Freshfields. Now, all of you, if you're here, it's because you're interested in international arbitration. You would know, of course, the treaties of Redfern and Hunter. And I walked into this conference room, and there were Martin Hunter and Alan Redfern. I mean, I thought I'd died and gone to heaven. So they were very generous with me. instead of spending 20 minutes, we spent much more time together. And I was in my hotel room that evening, and Andrew called me and he said, "Hey, Yves, you must have made quite an impression. Alan Redfern is representing the consortium of owners who are building the tunnel under the channel. And there's a cost overrun in those days, about 20 years ago. There were of something like about I don't know, $50 million or whatever, and they're looking for a chairman. It's an ICC arbitration. Would you accept to have your name put on a short list?" I repeat, I had nothing to do. As I said, certainly I would love to have my name go on a short list. And the following day, he called me and he said, "Yves, Alan has just rang me up. The list has become very short. They would like you to be the chairman." So, but there's a catch. This was in I remember very well. This was in April of 1993, and he said it's a fast-track arbitration for a variety of reasons. The tribunal is going to sit alternatively in London and in Paris, but they need a decision by September. So again, I had nothing to do, and I was very, very wise, because as soon as I came back, I accepted, obviously, and I got back to my office, and I went and saw, he was then a junior, he's now the star at Ogilvy Renault of litigation and arbitration, Pierre Bienvenu. And I went to Pierre and I said, "Pierre, est-ce que tu serais intéressé à être secrétaire du tribunal de la CCI?" I told him what the case was about. Et puis, il va y avoir, on va travailler fort, mais on va siéger à Paris, on va siéger à Londres. Et puis, on doit, peut-être que tes vacances vont y passer, parce qu'il faut rendre une décision avant le mois de septembre. And for Pierre, this was also the baptême du feu, and he's become, as I said, a very, very, very illustrious and excellent lawyer and arbitrator, and he's remained a very, very close friend of mine. So that was, Andrea, that was my first foray into the world of international arbitration as an arbitrator. And if you don't blot your copybook, once you're in the tent, you stay in the tent. And I've been, but again, I do want to stress, because I have no merit. A phone call to Andrew Fleming, meeting. There were Alan Redfern and Martin Hunter, and one thing led to another. Being at the right place at the right time in life is very important, and I was, and I treasure the day when I started doing international arbitration, because I love it. I like to say to my friends who are real judges that I have all the advantages of being a judge, but none of the disadvantage. I sit with some of the top jurists in Canada, the United States, Asia, Europe. I have appearing before me some of the best QCs, some of the best counsel, some of the best lawyers, in those countries. And here I am, at my age, continuing to do what I love doing and being paid for it. It's and I love writing also, not just speaking. I love writing, and of course, it's international arbitration is very sexy. I know that I don't know how many young lawyers, male and female, have rung the doorbell of the cabinet Yves Fortier, wishing to do international arbitration. Again, I was very lucky. One of those who rang the doorbell and who convinced me that she was the right person for me to hire as my colleague is Annie L'Espérance, and she's in the room here somewhere, but I can't see her. Ah, there she is.
Right there.
And yes, there is some attraction to traveling to New York or traveling to London or traveling to The Hague, but I think more importantly for young lawyers, serving as secretary to international tribunals, the opportunity to see in action some of the best and the brightest appearing before the tribunals which I chair or where I serve as a party appointed, and it's a wonderful experience for them. I mentioned Pierre. When I was at Ogilvy Renault, I had a series of young lawyers who worked with me, and this is how I developed the international arbitration wing of Ogilvy Renault. People like Stephen Dreimer, Martin Valasek, René Thériault, Alison Fitzgerald, Rachel Bendayan, Stéphanie Bachand, and many others. They've all blossomed, some of them more than others, but they've all blossomed and become emissaries, ambassadors for the firm. But you know, I remember a challenge sitting as an arbitrator for a large law firm. I hate to speak about material things like money, but it's important that I should. Your partners would, in a large law firm, would rather have you act as counsel. It's much more remunerative for the firm. You can involve many more lawyers of every different vintage. Whereas if you do arbitration as an arbitrator, well, you involve yourself, and sometimes if you're a chairman, if you're a chairperson, you might be able to appoint one of your associates as secretary to the tribunal. For a one-person or two-person, excuse me, Annie, for a two-person firm, this is perfect. It works extremely well. But for a 400 lawyer firm or for a 4,000 lawyer firm, as Norton Rose, and by the way, it's Norton Rose Fulbright, no Jaworski. Norton Rose Fulbright. It is not a paying proposition for those law firms. So those and because that's all I do today. As a lawyer, I did counsel work through after 1993 when I started. As well as work as an arbitrator, but now I only do work as an arbitrator. And when Ogilvy Renault became Norton Rose and acquired the Alberta-based McLeod Dixon, and today it is a 4,000 plus law firm. For someone like me who is a judge, and I have to be concerned with conflicts, obviously. Within the first 6 months after Ogilvy Renault morphed into Norton Rose, I had to turn down 5 important appointments because, conflicts sprung up in I remember there was one in Sydney, another one in Moscow, another one. So I regrettably, because I had been in the firm for 50 years, and it was like a divorce for me. It was, thank goodness, I've never experienced a real divorce, but leaving Ogilvy Renault at the end of 2011, December 2011 was very difficult. But I wanted to continue doing what I enjoy doing. I don't have another 50 years ahead of me, but Inshallah, God willing, si Dieu le veut, I have a few more years, and I want to continue. Doing it. I remember, I think it was Winston Churchill who said, once you once you find a job that you like, you never have to work again. And that is what has happened to me.
I think we have time for just a few more questions. So I wanted to ask you, and that's a great lead-in. So you've been involved with hundreds of cases, both as counsel and as arbitrator. Do you have a favorite arbitration case?
Yes,
And
the one that I'm doing today.
Uh-huh.
And that again, I'm telling you the truth, the whole truth, and nothing but the truth. I'm often asked that question, and the most interesting arbitration for me is the one that I'm working on today. That's the way I feel towards the case, and I can truthfully say to the people who have shown their confidence in me by appointing me that it's going to be number one on my agenda. Are there some cases that are more important than others? Of course there are. But what is my favorite case? Honestly, it's what I'm doing today. I could tell you that 2 years ago I chaired an ICSID tribunal, which in the case of it's in the public domain. Occidental Petroleum versus Ecuador, and we delivered the most important in terms of quantum decision up to that point in time. There have been others since. $2 billion. So that was a very important decision. I'm sitting as, again, it's in the public domain, I'm sitting as chairman of the UCOS tribunal. That's the case against the Russian Federation. That's a $100 billion claim by the shareholders of the successors to Mikhail Khodorkovsky, who are suing the Russian Federation for, as I say, $100 billion. So that's pretty significant. And we had a 5-week hearing a year ago, and now we're busy deliberating. I'm going to the Hague on next week for 2 more days of deliberation, and it matters not the amount in issue. I love arbitration because I'm comfortable in the sitting as an arbitrator, and I love the challenge, and there are some significant challenges, and I hope I can continue to do it.
Great. Well, right now there's a great deal of debate about whether arbitrators in investment disputes in particular should be more concerned with developing the law or with resolving the particular dispute in front of them. Where do you come down in that debate?
Much as I would like to answer the question the way most professors I know expect me to answer the question, that is, of course, it's the developing the law. For me, it's the case at hand that has to be resolved. And I'm not thinking of posterity. I'm not thinking of a legacy. I'm thinking of deciding the case that I'm seized of. And you have to. Yes, there will be, unfortunately, and as you know even better than I do, Andrea, in the world of investor-state arbitration, there are a number of disparate decisions. I don't know if that's the right word in English, but anyway, because there are different men, different women sitting as arbitrators, and they don't always see the world in the same way. That is unfortunate, but I think that I think it's important to decide the case on the basis of the factual matrix and the legal matrix that applies to that case, and not think in terms of I repeat, posterity or legacy or the future.
Well, picking up on that and not asking you to think, I will ask you to think a little bit about the future. What do you predict for the future of international investment arbitration? It's under attack, it seems, from all sides, with investors unhappy, states unhappy, civil society unhappy, yet it seems to continue. Do you think we'll see it continue?
Well, of course, as in any walk of life, any facet of life, it's the people who are unhappy whose voice is heard. I have seen and heard a number of people who are happy with the world of investor-state arbitration. I don't think that there are only dissidents or only critics out there. I think there are a number of people who are very happy with the system as it exists, and they don't want to see any change introduced. I believe that it's like the composition of the UN Security Council. I think that the ICSID convention needs to be changed, but again, as you know, in some respects, I think, as you know, it's not going to happen overnight because it requires consensus by 100 and how many states?
I think it's 48 now.
148? So it's not likely to happen tomorrow any more than the composition of the UN Security Council that reflects the geopolitical world of 1945 is going to be changed tomorrow because, well, just France and the UK, just to name them, have a right of veto, and they're not going to veto themselves out of existence. They don't want to leave that table. It takes a lot of patience. I admire people like yourself, who are devoting so much of your precious time to examining how best to improve the system, how best to improve the world of investor-state arbitration. We need people like yourself, Andrea, and people like Meg Kinnear, a Canadian. How proud!
A graduate of this institution.
A graduate of this institution, exactly. How proud! And the daughter of a former medical doctor to the Canadiens de Montréal, Dr. Kinnear. I'm also a hockey fan, don't forget. But Meg, who's the executive
Secretary General.
Secretary General, thank you, of ICSID, a Canadian, appointed before Canada ratified the excuse me, the ICSID convention. She's doing a marvelous job in Washington, and all of us who dabble in international arbitration, who are Canadians, are so proud of her. And she's introducing. It may not be obvious to everyone who is interested in investor-state arbitration, but she is improving the place. She's improving ICSID, and it's a number of very positive and things have happened under her watch. But again, I pay my respects and my compliments to people like yourself, Andrea, who are going to see to it that because I answered the question the way I did, I may have disappointed you, that we are not going to be to have comment est-ce qu'on appelle ça en anglais, là, des chevaux avec les œillères, merci, les œillères.
Blinders
but
on.
we should not be interested only in the case of the moment, as I answered earlier. But it is difficult to think in terms of posterity when you're being paid to resolve a case, and you have some specific facts that are that are before you, and you have some a legal matrix that you cannot put to one side and say, well, here's how I would do it. Sometimes I wish I could, but I can't.
Well, I think that on that note, we've overrun our time a little bit already, but please join me in thanking Maître Fortier for having come to talk to us today.
Thank you very much.
Yves, please accept this small token in gratitude for your coming here today to tell us about your life and career. I could have asked, I have at least as many questions yet again that we did not get to. And I'd like to recognize Elsa Paparamborda, my research assistant, who was really instrumental in organizing this conference. And I'd like to thank Giacomo Marchisio and the McGill Arbitration Society for putting together such a successful arbitration days and for including this interview in them. And I don't want to turn this into an Oscar speech, but I want to thank Maria Marcheski and Gina Sebastio, whose event planning is really unparalleled, and the generosity of Dean Dutra, yet again, for his support for this endeavor.
Oh, Andrea, this may not be an Oscar ceremony, but what about your husband and your stepdaughter?
And I recognize my husband and my stepdaughter, Sean and Elizabeth Duggan. And I could thank all of my colleagues here at McGill, and I should recognize especially Geneviève Sommier, who rang me up and invited me to apply for the Yves Fortier chair, and without her, I would not be here. So I thank you too, Geneviève.
Je vais vous acheter un verre de vin ce soir.
So a final just administrative note, if you have not yet signed in for continuing legal education credit, be sure to sign the paper that's on the table outside. And please join us in the faculty common room for a reception, and let's give Yves one last round of applause.
J'ai trop parlé.
Non, pas du tout, c'était très bien.
Merci.